Yes, now where have we got to? Your respondent's notice ground 3, I think. You'd given us the headlines. I don't know if you wanted to add anything to that before we move on.
No, I didn't. I should say my learned friend and I over lunch discussed the elixir serum or the Tang formulation label point to see whether there's one in the bundle. 287 is the best we can find.
Thank you.
Well, that's helpful and I'm grateful. It would be nice if we could have a better image of the label at some point.
I'll ask my instructing solicitor to try and obtain a copy for my client.
Or if you've got a sample, of course.
Well, the problem is that the label has changed since the original. We did give samples to the trial judge,
Yes.
but they were retained by the trial judge at the end of the trial. I'm not sure what's happened
No,
to
you never got them back.
He's probably looking 10 years younger now, absolutely.
How's his skin looking?
He was looking quite chipper last time I saw him.
So I can hand up what we have. It might be helpful even to see the liquid in the
It would
bottle.
actually, yes, thank you.
We do have one of the secret weapon original serums that was ordered, I think, in the last few weeks, and my client's current label.
Thank you. Anyway, this we think was the original.
Yes.
Take a photograph.
Well, yeah, but it's not representative.
Yes, I mean the elixir bottle is obviously not representative of the one at the time. I mean it shows you the liquid to the extent that the court wants to keep the samples that are available.
Now the defendant's one. Am I right in understanding that's the second label? Is it?
Second label, yes.
But
There is.
that's the one. But this one definitely does have the words original on it. Whereas
Yes.
the
second
one we
label,
had in the bundle didn't.
Did have
The
original.
pleaded second label. It's the second reformulation. So there was the limited edition launched on the 1st of December 2018, and then the original launched in the March of 19.
Sorry, I'm a little lost because what I'm looking
photographs, visible photographs of
at-
each one, identifying which it is.
Yes. Ms Metcalfe, what Lord Justice Stuart-Smith is suggesting is that if between you, we could, after the hearing is concluded, I mean not this afternoon, but in the next day or so, be sent an email with attached to it 4 photographs of the 4 different labels, each with each identified specifically, and then we'll.
Yes, we will.
Do you think that? I don't think that would be too
or
difficult.
or best available copies.
Best
Oh yeah. Oh, sorry. Yes.
as best as we can.
But
as
so
we
that
can.
we've got a pretty good picture of each of the labels.
And for the avoidance of doubt, identified however else you like, but also by reference to where it appears in the judgment, so we know which one the
Which
judge
one's
is
which?
talking.
Yes. The McIver serum there is the original, which is the second reformulation.
Right.
The first reformulation was described as the limited edition,
Yes.
Right.
and that was the one that was launched on the 1st of December. It's in the chronology,
Yeah.
but we clarify this in a.
And this is Ms Tang's YNNY.
Yes,
But that's her, and it says elixir on it, but it is her current label.
current label, and it is different from the one that was.
Just to manage expectations, your ladyship said the next few days. I won't be able to look at it until the weekend on Monday. So would that be acceptable as timing?
Sure. Yeah. Thank you.
Thank you very much. Right.
Right.
Thank you for obtaining those and doing your best between you. We're very grateful.
Just dealing with.
Thank you so much.
Just dealing with the misrepresentations as found by the learned judge at page
Yes.
103 of the bundle. Thank you. So, my learned friend's point on this, I understand to be primarily, he's saying that it's unfair for him, for the learned judge to have gone into material that wasn't part of the top 5 that was allocated at trial, and that creates procedural irregularity. Of course, the requirement for top 5 was largely aimed at the respondent side to limit the oral submissions, and so that the submissions wouldn't cause the trial length to go on, and in accordance with the overriding objective, etc., to try and achieve the resolution of the case at proportionate expense, so as to do it in that way. But in my submission, it doesn't preclude the learned judge from having referred to all of the available evidence.
Just as a matter of interest, were there written closing submissions, and did they cover all?
No, there were no written closing submissions. They didn't cover everything. There were
Moderately extensive opening skeletons.
There were extensive opening skeletons. My learned friend, actually, on the appeal seems to be limited in a sense, because he, in his appeal skeleton argument, he lists out the factors that at page 27, paragraph 45. And I have to say, I understood this to be the basis of appeal. Not there's no reference to best 5 or anything in this paragraph anyway. Paragraph 45 sets out the submissions before the lower court in relation to the different statements, and the complaint is at paragraph 46 over the page. The judge did not engage with any of the appellant's submissions. Likelihood of deception, in particular, was not analysed at all, despite it being a necessary component of Lord Oliver's formulation in the tort in Jiff Lemon. That is how the appeal is put, and the skeleton argument to my learned friend before the learned judge,
Which we now
at
have
page
at the back.
574 of the supplemental bundle.
Yeah.
Paragraph 35.
Yeah.
And it sets out the same list. So the learned judge had my learned friend's arguments before him in the skeleton argument, and plainly did not consider that they were had really sufficient merit to analyse them. And to be honest, when one looks at the statements, it's difficult to see that they do have any merit. So it's no wonder that the learned judge took the approach that he did. But that was his prerogative. He'd seen all of the evidence, he'd had all of the submissions, and he made the findings of fact that he made on misrepresentation.
So putting that submission into my own words, do I understand what you're saying to be this? That one applies the usual rule when an appeal court looks at a judgment of a lower court, namely, the judge is entitled to express his reasons succinctly. It's sufficient to express reasons which are dispositive of the issues. The judge is not obliged to engage seriatim with each and every submission made to him.
Yes, my lord.
That's what you're saying.
It states it rather more nicely than I.
Thank you.
My learned friend also stated that the learned judge didn't make a finding on the, let's call it the originator case. But that isn't correct either. Paragraph 63 of the judgment, page 104, I am satisfied that the misrepresentations relied on by YNNY took place. The ones that are relied on are the ones that were pleaded, and that was the originator case.
And one can put that in some context by seeing how the judge framed the issue right at the outset of his judgment, paragraph 4.
Yes.
YNNY alleges that Ms McIver and KMS have falsely stated on their business website and on social media that Ms McIver was the creator of Elixir Serum. YNNY says that constituted a passing off.
And he goes through the case law of Bristol Conservatories, claimant, dealing with exactly the originator point. So I don't, as I say, don't agree with my learned friend's analysis on that. Respondents ground 4. I need to deal with that. This reopens the issue regarding damage and whether the respondents suffered financial damage as a result of the misrepresentations. The way the argument goes, I've not been able to find any case law to at any level to support this. But the way the argument goes is that by the misrepresentation, Ms McIver, by laying claim to be creator, by the seamless transition, she was able to cut Ms Tang out of the deal, if you like. She was able to go to a new supplier. So it enabled her to withdraw all of her sales to Ms McIver, sorry, all of her purchases from Ms Tang / the company, and therefore to cause Ms Tang a loss and the company a loss. My learned friend says, well, she would have been able to go to the third-party supplier in any event. And I absolutely agree that she would have been able to go to the third-party supplier in any event, but only had she not misrepresented. So it was the misrepresentation that enabled her to create and cause the loss to Ms Tang and the company. And I'm not sure I can put it much stronger than that. It's in my skeleton argument. So
Not saying she couldn't have done it. You're just saying it facilitated it.
Apologies, I didn't.
You're not saying she couldn't have gone to third-party suppliers without the misrepresentation, but you say that the misrepresentation made it easier for her to do so.
It enabled the yes, facilitated and enabled
because she wasn't disabled before. That's what I'm picking up on.
Yes, it facilitates, but it goes further, because what she would have had to have done to continue her business was either to carry on purchasing from Ms Tang, so that the representation, there wasn't a misrepresentation, at least in relation to the transfer of the product, the seamless transition, or she would have had to have marketed the new product as being from a different originator, and that would have, as a necessary consequence, meant that she'd have had to be open about not being the creator of the product.
Why couldn't she simply have a product called Secret Weapon and sell it without saying anything about its similarity to or dissimilarity from Ms Tang's formulation?
Well, the effect of the judgment and the effect and part of the respondent's case was that this idea of seamless transition meant that the purchasing public went from one product to another, thinking that it was from the same originator. They utilising all of the same brand names, the same Secret Weapon, the Kate McIver brand names, that they wouldn't have realised that it was a new originator behind the product, and therefore misrepresenting the new product as the same as.
I understand that. I may be missing the point. I understand what you're saying, I think, and I understand it to include what amounts to the misrepresentations had a continuing effect. Fine. But if the misrepresentations had never been made, she wouldn't have been unable to switch to her product. It made it easier, the fact that she could create this sense of continuity, market it from a marketing perspective.
From a marketing perspective. But there are two aspects, because one is the misrepresentations concerning the laying claim to be the creator, and I think that's
But
what
she
my
doesn't
Lord's
need to
point
say
goes
anything
to.
about who creates.
No, but having done it and then effecting a seamless transition, it might be easy to put it this way. In the ScanSafe case, for example, Lord Justice Patton, as he then was, referred to a publicity release that had been prepared and that had been put out into the market, stating that they'd severed ties with their existing partner. I summarise, but severed ties with their existing partner, and it was effectively a new product. But and by doing that, they would have at least alerted a good portion of the prospective purchasers that there was no misrepresentation anymore. It was still found that there may have been people who'd slipped through the net, and it may still not have been a good enough strategy. But what we have here is there's no step to try and put people right on the misrepresentation. And had she put people right on the misrepresentation, she'd have damaged her own goodwill, because she wouldn't have been able to continue laying claim to be the creator of the elixir serum. I mean, the letters YNNY were on the second label. That's the all the labels get confusing. The second label meaning Ms Tang's product, but marketed under secret weapon. It said YNNY on there. She was worried. There was evidence in the bundle that she was worried that people would find out that that the product was from a different source, or they could get it cheaper elsewhere. I can find the document if it's helpful. Do you have a page number?
Can I just try that?
I just asked my solicitor to find it, because she had her hands on it earlier. Thank you.
Can I just try from a slightly different angle? Because I think maybe it's slightly at cross purposes. As I understand it, with white labelled goods, which are not protected in any other way, the intermediate seller can, if they wish, stop buying from their original supplier and find a different source.
Yes.
And if they do that, they can then sell. Your complaint is what they can't do is misrepresent that they are the originator of the original product, and this is the same. Which is why I was picking you up on what is essentially a causation or strength of causation problem, because I think you need to be precise, and I'm not quite sure where you are on the spectrum. That's not meant to be a medical insult, but you need to be precise as to whether you're saying she could not have launched her alternative product without the misrepresentations, or what I think is a more realistic approach, the existence of the misrepresentations were beneficial when she launched.
Yes, I think
It's the latter, isn't it?
maybe a better way of
So,
stating
so as my lord was saying, it is basically she capitalised on her misrepresentation.
Yes. Yes.
Which is-
And had the truth come to light, this was, well, she had capitalised on it. This was the basis of her brand. We can see there was no point for her to do it other than that it contributed to her own goodwill. And
Well,
therefore she...
I fully understand. Well,
Yes.
I'd like to think that I more or less understand your case on the advantages to her of the misrepresentations and what you've said this morning about the impact of the misrepresentations. It's just, at one point I thought you were straying beyond facilitating or assisting into straight enabling, in the sense that she would not have been able to have launched her own product without the misrepresentations, which at the moment, speaking entirely for myself, seems to me to go too far.
Yeah, I agree, my lord. I don't mean to say that it was enabled in that sense, but
Okay.
yes.
Thank you.
It's page 346 of the bundle. It's within the Facebook messages. The blue messages are Ms Tang and the grey messages are Ms McIver. This is in amongst their discussions regarding products, but I know you don't, let me discuss more detail whenever you're ready. I know you don't want to sell, but I felt obliged to tell you, as obviously he could approach you direct, this was the investor. I don't know what to think at the moment, as I can't keep selling the serum in the same bottle with you selling it in the same area and cheaper. Like Anna today, people know instantly. So she had her worries that if the truth came out about this, she would lose sales. And who would she lose sales to but the originator of the product? As I say, I mean, respondents ground 4 is, in addition, I've already dealt with the damage to reputation issues that the learned judge had regard to. I don't intend to revisit those. I would just say, in response to my learned friend's point, that this was an evidentiary finding of fact. I'm not sure that can be said that within the that I would be challenging a finding of fact in this regard. I'm not sure that can be said in light of paragraph 64 of the judgment that deals with whether there was any loss of sales. It plainly isn't dealing with loss of sales to Ms McIver, because that is an obvious matter of fact that she stopped purchasing them, so there were no more sales to Ms McIver, and she lost that income stream. So I'm not challenging the finding of fact in here. It's just that it was absent the judgment, really, that rationality. It is a pleaded point in the loss and in the forms of damage that are pleaded under passing off. Just turning then to copyright infringement.
Yeah, on that, it's my fault. I should have asked Mr. Smith this question, but since you're addressing us, I'll ask you. It's a question really that goes to both of you. I'm a bit mystified by paragraph 81 of the judge's judgment, because I think there's some words missing, and I've want some enlightenment from both of you as to what the missing words are. Because what he says is, in closing, both counsels stated that YNNY's case in respect to copyright stood or fell with the defendant's assertion that the use by Ms McIver of the copywork relied on, namely her marketing materials used for promoting the Elixir serum, full stop. And there's obviously meant to be something more after that.
Well, the position was at trial, it was agreed that the only issue on the copyright, in terms of infringement of copyright, the only issue for determination by the judge was in relation to the license. I should, and I believe that that is the wording that was attempting to be utilised there, but it was obviously fallen short. Part of the reasoning behind that, and my learned friend makes this point about section 18 and section 20, he might be right about that. However, I'm not sure that that really matters, because if one looks at the defence, take my lady and my lords to paragraph 40 of the defence at page 129. My learned friend skipped. He said, "Oh, paragraph 26 is denied," but skipped over the rest of it. Save in that it is admitted that the first defendant and Ms Diamond have issued copies of certain of the materials in YNNY 10 to the public, and made such copies of materials where such materials appear on the Kate McIver website and/or on Kate McIver social media posts. So, in terms of the acts of infringement, they were admitted. The only question, and then the defence was, it was licensed. Well, the point that was dealt with by the judge, was raised at trial, was the licence wasn't in perpetuity. It came to an end on the 30th of November by an obvious matter, of course, because she terminated the contract, and it couldn't have been thought effectively summarise it, but it couldn't have been thought that a licence would have continued in circumstances where she wasn't purchasing the product anymore.
Well, I understand that, but then the other point that's taken is that if one looks at what the judge says, he makes the finding on licence, and that's perfectly clear. As you say, he finds the licence came to an end on 30th of November 2018, with no challenge to that finding. But then what he says is use thereafter, if there has been any, was infringing use. To which the submission is, but that was the judge's job, was to decide whether there had been any use. Because if there had been none, then there was no infringement.
Well, one can't help but agree with that sentiment. The issue was that His Honour Judge Hacon decided to have a witness statement filed in order to deal with the period of infringement, period of use. So that was filed. It isn't before this court because it obviously wasn't evidence before His Honour Judge Hacon. But he chose a simple method for dealing with it. The main reason was that it wasn't clear at trial just when the post, well, on some of the posts it would have been clear that they were made, but and in fact I think all of the documents it would have been clear when they were posted. It wasn't clear if and when they'd been removed, particularly the website pages. It was known that on instruction at trial, I was able to confirm to the judge that my solicitor had looked at the website, at the Instagram pages, that I think it was that morning or the day before, and had found that everything was still there. So nothing had appeared to be removed. There was evidence. I dealt with it in evidence. I asked the director of the company whether anything had been removed. It's in the transcript at page, in additional point, page 566. Deal with that issue with the witness.
You're going a little quickly.
Apologies. Page 566.
Yeah.
It's about a third of the way down.
Yeah, just for my notes, this is day 1 of trial, day 2?
Day 1 in the afternoon. Yes, day 1.
Thank you.
All of the Instagram posts that I've referred to, and it's something you said before about Facebook, it is all there to be seen now. I suggest to you that these Instagram posts are there to be seen now. They are still on the Instagram
I'm sorry
page.
to interrupt you. Again, just so as I'm clear, this is Mr McIver, is that
Mr McIver, apologies, yes.
Yeah.
I have not removed anything. There have not been removal of any of the materials, so they are continuing publication to date. Are you asking if I have removed anything historically? Well, I'm asking whether the documents, the Instagram posts that I've referred to have been removed, or if they're still on Instagram. I've not removed anything historically, but as this post has got 6 comments on and referring to another product, I think I've done some analysis on the customers you may be referring to here. So it went off on a different tangent. I think the answer to the question was that all of the Instagram posts which I've referred to are still on Instagram. They have not been removed. And he says, so those particular ones, I've not personally removed them. Are they still on Instagram? Do you not know? I cannot say with absolute certainty because I'm not the only one who's got access to it, but I have not removed anything historically. So that was the totality of the evidence.
Right, so the bottom line on that evidence is he personally had not removed anything.
No.
And he didn't know one way or the other whether someone else might have done.
But there was no evidence that they had been removed. And the kind of, both the website pages, I'll go to them in a moment, but the website pages and Instagram posts are of a nature where they would stay in publication until removed. And my learned friend criticises the absence of a pleading of continuing breach. I didn't know whether he was saying that continuing breach couldn't apply to copyright infringement. I don't believe that's the point. I think he's saying that that it wasn't pleaded effectively. I say that, but when one pleads out a case by reference to the types of documents that stay in continuing publication, it's obvious that there's a continuing breach, and that once the license came to an end, the breach would have continued. And I say that was obvious to the judge, and that accounts for his the wording of his judgment, and also accounts for the order that he made requiring the witness statement. I've dealt the 4 infringing items copies are at 310 and 314 a bundle. Those are 2 of them. Those are Instagram posts.
A minute.
And 314.
310 and 314. I should say, it says at the bottom on 310, Instagram post 29 2019. It was agreed at trial that that's the wrong date. It should say 2018. So those are the 2 Instagram posts, and I've raised the point that there was no evidence that they were removed or deleted. And then at page 316 and 317 are the 2 website posts. Now,
I beg your pardon.
sorry, the 2 website
Yes, but
pages.
which pages?
Oh, it's page 316 and 317. They just follow on. Both of these pages relate to the limited edition secret weapon serum. So that's the first reformulation. You can see the top of 316, my lady, my lords, limited edition, and it's the new style bottle, etc. on the photograph. And then over the page at 317, about halfway down in bold, it says limited edition secret weapon also. Now, this product wasn't marketed until the 1st of December, and that's stated in the chronology.
I'm sorry, trying as hard as I can. I can't read 317.
Yes.
Is it possible to provide a better copy?
And we'll get another better copy.
Electronically, if that would make it easier.
We'll do our best to get a copy. What I would say is that it was accepted that this was a substantial part, a copying of a substantial part, and so the actual contents of the infringement as such, or in my submission, not to trouble my lady and my lords, but it does say, and I will try still to get a copy, but it does say limited edition about halfway down.
You can read that, actually.
You can read. It's one of the few bits that is legible. So both website pages relate to a product that wasn't marketed until the 1st of December, and that's apparent because in the chronology...
Well, I assume you're right about the chronology, but why could this not have been posted the day before?
Well, we don't know the exact date on which it was.
Uncommon for marketing to precede actual availability of the product.
It is worthy of note that the Liverpool Echo article was published on the same date as the first Pelham reformulation was first marketed, and the parties had agreed for the purpose of the chronology that the date was the 1st of December.
My lord, this is the first time that the respondent has attempted to date these documents. It's the first I've heard of it. It wasn't put to the witnesses at trial, and my Lord Justice Arnold makes the point that just because the 1st of December was the launch date, it doesn't mean this wasn't put up on the website earlier than that. So in my submission, it's another unfairness where I'm being ambushed by something that has never been properly pleaded or run at trial. Forgive me now.
And a further point that I could...
I'm sorry, it's being suggested you've ambushed the appellant.
with all due respect to my learned friend, it is their website post, and they are the appellants are the ones who know when it was posted. They didn't produce evidence at trial to that end. The only evidence before the court was that it wasn't marketed until the 1st of December. The respondents are without knowledge as to when the post was put onto the website. So the fair conclusion to come to on the evidence would be that it was, the inference has to be the 1st of December unless there were evidence to show otherwise. However, again, I go back to the point that the learned judge saw fit to have a system in place to work out, which would then also suit for damages assessment as to the period of use, whereby he ordered a further witness statement of use.
Can I cut to the chase on this issue? Because the way I'm seeing it at the moment, and obviously this is a provisional view that I'm expressing because I have to deliberate on the arguments at a later stage. But at the moment, it seems to me that there is actually really no dispute as to continuing availability of the relevant posts on the website and Instagram after termination of the license. And the question, therefore, is the continuing availability of the posts sufficient to establish infringement after the date? And I understand your submission, which is you say, well, the only issue at trial was it licensed or was it not licensed? And it inevitably follows that if the license comes to an end, anything that happens thereafter is unlicensed. I understand that argument. But this is where we get into the distinction between the different types of restricted act. And you acknowledge that there might be some force in the distinction between section 18 and section 20. I mean, the inference I'm drawing, and you'll correct me if I'm wrong, is that that distinction was not discussed at trial. But it may well be relevant to the question of whether there's an infringing act after the 30th of November.
It wasn't discussed at trial.
Yeah.
It was admitted, the section, well, I say the section number, the issuing of copies to the public was an admitted fact in the defence. And that perhaps accounts
I think it's being suggested by Ms Smith that it wasn't.
Not
You're
section
not
20.
going to play, advocates' tenets here.
Issuing copies is section 18. Communicating to the public is section 20, and section 20 is not pleaded.
Yeah.
No, but what is pleaded in the defence is that it is admitted that there was an issuing to the public.
Exactly. Yeah, I understand.
Hence why the issue wasn't dealt with at court, because had it been said, no, there was no issuing to the public, or I'm not saying they should have referred to section 20, but had they denied the fact of issuing to the public or at a relevant date, then the respondents may well have applied to amend to plead the correct statutory section. But where it's admitted, it doesn't become an issue between for the purpose of determination before the court. And in my submission, the court can assume that the only issue was whether there was a licence and how long that licence lasted for, and that the continuing use of the post thereafter is just a form of continuing infringement by whichever section one has regard to, and that until the posts are deleted or removed, there's a cause of action that arises each day. And that has to be right in. If I'm not right on that, it may cause difficulties in terms of limitation arguments potentially on cases in the future, and also it doesn't make sense then to have an account for damages for a hypothetical license fee for a period of time.
Limitation is a separate point. I mean, it's conventional in copyright cases, whereas you rightly say, provided restricted acts are committed, you have fresh infringement every day. And the effective limitation is not to bar the claim at all, but to limit damages to 6 years before issue of the claim form. And we're not in that territory here because we're not into 6 years past. So we forget about limitation. The question is at the liability stage.
Well, liability gives rise to a right to either loss and damage or to an account of profits measurable by reference to a hypothetical license fee for a period of time. Now, if the act is, it is only if the act is continuing, in my submission, that one calculates the period of time in order to calculate damages. It flows, the quantum flows from liability.
Yeah, all right. I think
So
I got the point.
my lord has my arguments.
Thank you.
If I could just turn my back a moment.
Certainly.
My lady, my lords, have no further submissions.
Yes, Richard. Thank you very much. Yeah, anything in reply?
Very briefly,
Certainly, yes, Mr. Smith.
my learned friend talked at one point in his submissions about automatic misrepresentations. And in my submission, there's no place for considering the question of an automatic misrepresentation in passing off. It's a specific kind of misrepresentation which has to deceive the relevant consumer. He also talked for a while about confusion. Again, confusion is not the touchstone of the tort, it's deception. In the context of the white labelling agreement, in my submission, different principles apply. And in my submission, the authorities my learned friend has relied upon just aren't opposite in this case.
Thank you.
My Lord Justice Arnold referred to the judge as entitled to come to that conclusion, and he doesn't have to state his reasons in full. In my submission, in terms of misrepresentation, the judge just hasn't mentioned my arguments at all, and that has fallen below the reasons threshold, which the judge had to do in engaging with the arguments. Finally, on passing off, my learned friend's damage, his points on damage are confusing the test which is to be applied to damage in tort cases in terms of causation. The court looks at what would have happened if the tort had not occurred. All of my learned friend's points were about the tort occurred and then something would have had to have happened to correct the tort. So the misrepresentations were made, and then in the absence of a press release to correct that, there was therefore damage. That's not the way to look at it. One looks at the misrepresentations were not made, and then what would have happened? Well, my learned friend accepted that the defendant, the appellant, was perfectly entitled to go to a reformulator and reformulate and sell. Now, if that made it easier, that is not about the respondent's loss, which is what the damage hypothesis looks at. It's about the appellant's gain. And one party's gain isn't another party's loss. It doesn't follow. Gain is about restitution, loss is about tort. And in my submission, the extra ground that my learned friend relies on just doesn't work on normal tort causation principles. Finally, on copyright infringement, my learned friend seemed to suggest that because the defence admitted issuing copies to the public, which is really about tangible articles, not websites, what it should have done is deny Section 20, which hadn't been pleaded, communication to the public. That's about websites.
Well, can I ask you a question about that? Because I understand the point you're making about the distinction between Section 80 and Section 20, and undoubtedly it's a very relevant distinction in this context. But the problem I have is that on your submission, it seems to me that the admission should never have been made, and yet you did make it.
If it was made, but ultimately it's in the past tense, and it admit, well, so I didn't plead the defence, and I don't know why it was.
I understand that.
in my submission, it wasn't made. It may not have been made out, but I don't think the evidence really went to it. So I saw the evidence, and as it was admitted, I didn't see it. The relevant copyright infringements relied on are all websites, and in my submission, the correct section is Section 20, and it is for a claimant to identify what they say is the infringing article, the infringing thing and the infringing act, and the claimant has not done so. And it cannot be right that a defendant has to deny cases that were not put in the pleadings. So there's no evidence of any infringing act, because all of the websites relied upon either were not dated, and I see what my learned friend tries to do to date some to the 1st of December, or were dated within the license period. So the act of putting it on the website was a permitted act because it was licensed. There's no plea of authorization. There's no plea that at some point this became an infringement, which must be a necessary prerequisite to be a continuing infringement. And it's not right that when a license ends, that immediately makes everything that has gone before infringing. If someone has made one copy, they have that copy. It's not an infringement that that copy still exists. If someone has issued copies to the public in the past, it's not an infringement when the license ends. One has to look at the terms of the license to see what happens, and that didn't happen because of the way the case was put by the claimant, the respondent. So unless I can assist the court further, and I'm sorry for my low volume to my lord, to my lady, those are my submissions.
Thank you very much, Mr. Smith. Well, can I thank both of you and those that sit behind you very much for the preparation of the bundles and all materials, for which we are grateful. Sorry, did you want to say something?
Apologies, my lady, my lords. My learned friend and I had agreed, I think last night, that the costs of the supplemental bundle application ought to be reserved to the fine after the determination of the appeal. I hope that, of course, with your
no, well, we would be.
Sorry, I didn't mention it because your ladyship was saying yes, that's a great idea, but I was to say we had agreed that. Yeah,
No,
cost reserve.
well, thank you for bringing that to my
Only
attention. No,
because if I didn't raise it, I think it would end up being possibly no orderous cost. So
oh no,
they're reserved.
No, we're going to reserve our judgments, and that of course means that we've no idea what the position will be about cost because we haven't decided how the appeal's going to be. We'll send out drafts in the normal way. The typographical and minor factual errors only, please, not in order to re-argue the case. Please note the embargo that comes on the top of the draft and ensure that we get a proper list of who's going to have access. Although I don't think the commercial world will be completely undermined if in this particular case, but we take the embargo very seriously. Anything else I hope we'll be able to deal with on paper. I hope you'll be able to agree a draft order, but if you can't agree about any matters such as costs, please make brief submissions in writing and we will determine it on paper. And thank you all very much indeed.
All rise if you're able to.